Hello, I'm retired Columbine High School Principal Frank DeAngelis. This coming April will mark the 20th anniversary of our Columbine High School tragedy, and I can't help but reflect on the many lessons we learned since April 20th, 1999. In 1999, we didn't understand the benefit of Safe to Tell program that in the past 15 years have saved so many lives of Colorado students in crisis. In 1999, we also didn't grasp the critical importance of information sharing between schools and law enforcement to protect students and staff from school violence. Sadly, there is still confusion over the laws around sharing information. It's time to clear up that uncertainty. I'm joined today by a dear friend, Colorado Attorney General Cynthia Kaufman. Cynthia has been an advocate and national leader for school safety issues, and she's going to talk about how to make information sharing work for you.
Thank you, Frank, and thank you for all that you've done on behalf of students in Colorado and around the country. As Attorney General of a state that's been changed by the Columbine tragedy and has weathered too many acts of school violence in the 2 decades since, I'm passionate about improving school safety. We train our students to speak up when they're concerned for their own safety or the safety of their classmates, and they're doing it in record numbers. Their Safe to Tell tips are saving lives. By sharing information about what's happening with your students, you also can do your part to create a safe learning environment and prevent school-related violence. Schools and districts and their law enforcement partners, social services agencies, mental health providers, and the judicial system all need to share information with each other to keep kids safe. We've heard from many school teachers, administrators, and staff members that some of their biggest concerns about information sharing actually are misconceptions about what the Federal Education Rights and Privacy Act, or FERPA, does or does not permit them to do proactively when responding to safety concerns, including threats of school violence. To help dispel some of the misconceptions about FERPA, I issued a formal Attorney General opinion that's designed to help schools and districts understand the information they should be sharing. The full opinion can be found on the Colorado Attorney General's website at www.coag.gov. But I want to take the next few minutes to highlight some of the practical information that can be found in that opinion. First, it's important to know that FERPA has limits and doesn't apply to any and all information about a student. It covers only education records. While this definition is broadly worded, not all information that comes into the hands of an educator, administrator, or other school staff member is an education record. FERPA mainly concerns those institutional records kept by a single central custodian of records. In other words, these are the official records that used to be kept in a filing cabinet in the administration office, but now are online in a secure database. I want to describe 2 particularly important categories of information that are outside the scope of FERPA's definition of education records. The first is information about student behavior that an educator learns through personal observation, peer reports, or social media. Educators can share this information with school staff, other educators, and with law enforcement agencies. This includes observations and other personal knowledge about a student's behavior, for example, behavior that a teacher sees or overhears. It includes reports, whether written or spoken, about a student from a student's friends or peers. And it encompasses threats of violence or other information shared on a social media platform like Snapchat or Instagram. The second important category of information that isn't treated as an education record and can be disclosed without parental consent is records maintained by school security personnel. Many schools employ staff tasked with maintaining campus security. Others assign that responsibility to an administrator. And some larger districts are fortunate enough to have a school resource officer assigned by their county sheriff or police department. Whatever the arrangement, a school should designate that person or group as a law enforcement unit, which then exempts the information that they maintain from the definition of education records. Under FERPA, investigative reports and other records created and maintained by a school security staff can be readily shared with other law enforcement agencies. This includes video recordings made to enhance safety in and around a school building. It's important to note here that Colorado schools must share education records with law enforcement agencies conducting criminal investigations. Colorado statute requires schools to share disciplinary and truancy information upon the request of a criminal justice agency if the agency is investigating a criminal case or a truancy matter. In addition to these examples of what isn't part of an education record, there are some circumstances when even the private contents of a student's records may be disclosed without parental consent. There are two specific exemptions that I want to make sure you know about. First, school staff can share education records with other school personnel who have a legitimate educational interest in the information. This includes school security staff and school resource officers who may receive any information helpful to maintaining campus safety and security, including personally identifiable information from student educational records and Infinite Campus. And second, schools can disclose otherwise protected information with appropriate persons in order to respond to a health or safety emergency. FERPA provides that school officials only need to be able to express in words what led them to believe that there was a significant threat to the health or safety of a student or others. That discretionary decision is to be made based on the information available at the time and should take into account the totality of the circumstances. FERPA encourages schools to not delay the disclosure of information until an actual emergency is materialized. The point of this exemption is to release information in enough time to keep people from harm. This includes disclosures to mental health professionals and law enforcement officials who may be helpful in protecting against a threat. And perhaps the most important thing to take away is that when faced with potential safety risks, schools should err on the side of proactive disclosure and safety. The United States Department of Education has made it clear that it will not second-guess judgments made in the face of a potential emergency. And FERPA doesn't give students or parents the right to sue for an unauthorized disclosure of protected information. The law applies only to systemic violations of student privacy, not to good faith mistakes in judgment. I hope the Attorney General's opinion and this discussion reinforce that FERPA is more flexible than its reputation would have you believe. I encourage your school and district to adopt policies that avoid well-intentioned but overly restrictive guidance on information sharing. Thank you so much for all that you do to educate and protect Colorado's children.